Item 11, Mr. Lawyer, business.
No report tonight.
No report, Mr. McInnes. All right, Madam Superintendent, your business.
Yes, I have given all of you a letter here today, and in the last workshop, Mr. Chairman, you brought forward an interesting question, and I gave it a lot of thought, and I've decided that you are probably right. So I do believe that both the board and superintendent need to be able to receive independent legal advice because we have separate duties under Florida law and district policies. I'm not your boss, you're not my boss. We have separate duties. Many daily functions can be managed by our current attorney, who's done a wonderful job, but when questions about duties and roles we each play come up, it is important that we each have our own legal advisor. Recent requests to the board attorney to offer guidance on the superintendent's responsibilities are an example of where separate lawyers are useful. As we move forward with policy revisions, having an attorney guide the board on sound policy is important. But because the superintendent carries out those policies, having an attorney guide that duty is equally important. And as you read my letter, I am requesting those legal services.
And if I remember, I wasn't a member of the school board at that time, but I think, Mr. Walker, you were, that this was brought up once before in the past. I think Superintendent Jackson, you brought this item to the table several years ago.
5 years ago.
Yes, ma'am. And I wasn't a participant at that time, and Mr. Walker, you were, and Mr. Destin, I think you might have been on the board at that time too. Mm-hmm. Mr. Bryant, you're like me. You weren't here yet either. So certainly I'm open to any discussion or commentary by board members.
Well, there are pros and cons to that situation. One of the cons is, after, looking back at 30 years of public service, in which case I've been in a situation where we had two attorneys addressing the same issue. As you may not be surprised, attorneys can come up with completely different answers. So if you have two attorneys, one working for the superintendent, one working for the board, who don't agree, now you're in even worse shape than you were when you had one attorney. I believe that the board attorney that we've hired to service the district has done a good job of representing both our situation and Ms. Jackson's. And I don't want to put us in a situation where we have different opinions from two attorneys that work for us. I've been there. It's not a good place to be.
All right, point well taken. Mr. Walker, do you have anything?
No comment.
No comment. And so, how do we proceed, Mr. McInnes? I mean, we have a request from the superintendent of the school board, and I assume that this request involves funding, and that would fall within the prerogative of the school board, but certainly we would look to Mrs. Scallon to provide some idea of how such a thing should even occur. Should, I guess, this be a voting matter?
Well, there are certainly times, and you know when those have occurred, when the school board does authorize separate legal counsel for the superintendent. It happens a lot in personnel matters. When we're going to have an appeals hearing, say, to a termination or a suspension, it is common practice that we recommend that separate counsel be retained for the superintendent. They present the case because I represent the board in those matters. That's one situation where it's appropriate that there would be separate independent counsel to avoid a conflict situation. Secondly, when there should become an issue or disagreement between the board and the superintendent as to their roles and responsibilities, and under Florida law there are separate roles and responsibilities set out for the school board and that set out for the superintendent. If there were legitimate legal concerns between the two constitutional positions, then case law in Florida does provide that each entity should have independent legal counsel funded by the district. So those are the situations we've discussed before, so that if the superintendent believed that there were a situation of conflict between her duties and responsibilities and those of the school board, then she would be entitled to have an attorney look at that issue or advise her on that issue if there were a dispute between those roles.
Jeff, listen, you just got through saying, and for all the years that I've been on this board, we have something already in place that takes care of what supposedly you're describing. You came before this board numerous times, and you've hired a separate attorney for Mary Beth.
Correct.
And everything, but now I'm hearing you say that, in other words, this thing that's now being requested is all of a sudden going to be necessary when we've always dealt with it in the past. But if we approve what I'm assuming that we'll be asked to vote on at a later date, then it's an open-ended thing to where it won't be brought back to the board on each individual case. And I absolutely, by statute, as you said, and by the fact that all these years, we've always provided the superintendent without an extra counsel if you came forth and asked us to do so because of what you described. But now, why is it all of a sudden that you're now making it sound like that way we've been doing this all this time is not adequate and that we need now to do it a different way?
No, sir, I'm just explaining that in the past.
But you will agree with me that we've always handled it.
Yes, sir.
And taken care of the superintendent.
That's correct.
Whoever it was. They've never asked this board in the 20 years I've been on here that we did not provide them with counsel if they asked for it, if it became necessary.
Right.
So only question that I have is what is different now than with the way we've been handling it? What in your thing, what is different to where we're now asking to do something that we've had something that's worked wonderful for all these years that we now decide that we no longer need to do that? What is happening?
And
that
Mr.
make us
Walker,
change?
I'm not trying to describe any different situation. I was just confirming that when there is that conflict situation, then as we've always done, the board does fund separate counsel for the
And
superintendent.
we've never turned her down,
No, sir. No, sir.
he or she.
And so I'm just confirming for you, that is something that is appropriate.
But you're still not answering my question, Jeff. Why is now we've decided that it's necessary to do it differently from the way we've done it in the past to where we may, and I want to make sure we take care of Mary Beth if she needs separate counsel. But I don't see any reason or anything that's changed that would want us to make a completely different type of policy to deal with it. I don't
Yeah,
see no reason to do so.
I wasn't hearing that in what I've heard what you've heard. I was hearing that in conflict situations, which I've described to you we've done in the past, that she was asking to have independent legal counsel.
Yeah, and as Mr. Destin pointed out, and Lord, I love you like a son, but let me tell you, the more lawyers, the more complicated it gets. And I have to agree with Mr. Destin, and hey, I don't want any of our employees to not be properly represented, and I wish that I could make sure of all of this. But what I'm saying is, if anyone can show me any time in the past that we've not adequately taken care of the superintendent, whoever it was, whenever it was, I mean, then I may be open to change it. But I don't see any reason to change it. I mean, because, hey, Jeff, we've had as many as 2 or 3 different law firms representing us on different issues numerous times through the years. I mean, I can remember one year that we had at least 6 different attorneys working on 6 different things, and at that particular time, it was representing the superintendent, and not Mary Beth, but another one. And if somebody could give me a reason why we need to change, I'll listen.
I'm just confirming, Mr. Walker, that we have in the past provided independent counsel in conflict situations, and that's what is entitled to be done. It would be totally the board's decision if the request were just for an extra attorney to do day-to-day operational things, then that's totally in your jurisdiction. The superintendent doesn't have the ability to seek that. That's a total funding issue for the school board. It's only in conflict situations where the superintendent could seek a counsel,
But Jeff,
which is what we've done in the past.
We have a.
Yes, sir. I'm not,
Hey, how long have you been on this board, Jeff?
since 1990.
Okay, how many, numerous times that you came to this board for that very thing, and it's been adequately handled. I mean, what I'm saying is, why do we need to change anything? I don't understand that. It's never not been adequately handled
Right.
by you.
I would say you
And
need
it-
to address the superintendent with that question. I mean, this is
Well, I mean,
her
whoever I'm
request.
The
addressing.
question is not a matter of handling personnel issues. That's the only time I have any representation whatsoever. But when a new board policy is put in place, I have no legal advice, and I'm the one that's required to carry it out. I'm entitled to this representation. I need this representation, and I want this representation.
Do we have a conflict situation that I'm unaware of?
We have them quite often. But he represents you. He doesn't represent me. So whenever I have questions about school board policies, and in fact, I have someone here tonight that is my personal, on my dime. And if you would like to ask some of those questions of him, you certainly may. But I need someone that I can talk to. Jeff is going to write a policy for you. I may not agree with what you want me to carry out in that policy. I need to know if legally what my stance is in that. And I don't know what's so funny, but apparently this is humorous. But I am entitled to this, and I deserve this. I've been 5 years without anything. Jeff's been wonderful. He helps us. But the only time I get any legal advice is when it is an employment issue, and or a something like that. I don't get to have someone say, Mary Beth, this policy, I've read this policy, I have some questions about this policy. I don't have that, and I want that. I don't need someone for day-to-day operations. Jeff does that just fine. I want someone to help me. When we're bringing forth new policies, I want them reviewed because I'm the one that has to carry them out.
Sounds like you feel we might be or have the potential to be in an adversarial relationship. I've never felt that was the case, and I hope that it's not, but I can see that this system would be ripe for those kind of problems. We set policy, you're our executive. It sounds like we have an attorney now who may say you don't have to follow the policies. And so, and above and beyond the fact that there would be a real dispute about what legal matters the second council would handle, I can see this would be ripe for a lot of issues, and I don't think we're there, and I hope we never are.
Well, I know what my right is and what I am entitled to, and I will fight for that.
Sounds like we're at that adversarial position already.
All right, so.
Well, that's your opinion.
Certainly is.
All right, folks, so then I need some procedure advice, Mr. Attorney. And I think, so we've received the letter, and this now is a matter of public record. And these school board members can inquire of you as to process and procedure for entertaining the superintendent's request.
Correct.
And I haven't really had a chance to study it carefully, but I think I understand it. I'm assuming this would be an agenda item to be voted on? Is that how that would work?
Yes, sir.
At
that
a
would
future
be-
meeting?
That'd be a way to do.
Mr. Bryant, you have any questions? I haven't turned to you. Board members, any ideas or questions about that at this point?
No, I think that's the course, and since it was not on tonight's agenda, it'll have to be at a later meeting.
Yes, sir. And not knowing when that might be, it might be that board members, if you have questions or thoughts about that you would like to present when we can meet in the sunshine, then we can discuss that further, I guess.
Well, it's very simple. If any one of the board members, after you had a stint to study, if you or Dewey or me or Mr. Brown wishes to put it on the agenda as a motion, then that's it.
Yes,
Then it comes down to the whole crux of one thing. If 3 people raise their hand, it's a done deal. If 3 people don't, it's dead. And that's what it amounts to. And as Mary Beth mentioned, when she says she's entitled, there's one thing about it, if 3 people of this board doesn't vote for it, it's over with.
But now that's the question.
Well, she, of course, can
I
go.
think-
Well, I mean, yes, but what I'm saying, as far as this board's concerned, if
On our end.
if that's it, and then Mary Beth at that point in time can do whatever she feels like she wishes to do, but if you or me or any of us wish to, the next board meeting, put it on the agenda, and then
Yes,
if
sir.
we want to discuss it more, we'll
Right.
discuss it, and then when you call for a recommendation, and we call if we get a second, and if 3 hands come up, it's solved. If 3 hands don't come up, then that'll be back in Mary Beth's court.
Right. And I guess the questions I have along those lines, Mr. Walker, would be budgetary. Assuming that we are even going to consider this, is how would we pay for it? We have an approved budget.
Well, I
and
have
so-
the utmost confidence in our attorney, and I've been around for many, many years, and it may well be, and if I was in Mary Beth's case, maybe I'd feel like she does. But all I know is one thing, is for many, many years, we've had one attorney that's basically served the superintendent and the board. And all them years, I've never really known it to be a problem. But and like I said, I'm not sitting in her suit. If she feels that way, then fine, and if 3 members of this board wishes to support it, but I can tell you this, I will never support having to put 2 full-time attorneys on the
You're
payroll.
not full-time.
Well,
You aren't
whatever, where it's open-ended, I
Well, the
cannot
chairman
support
brought this
that.
up in the workshop.
What I asked for, Ms. Jackson, was a explanation from the attorney to give some information about joint client relationships.
Correct.
I did not propose that you have your own attorney, nor we have our own either. I just wanted some clarification on how that worked.
And I need clarification as well.
Well, and we expect to get that on the 22nd, I think, if I remember correctly. But at the same time, you did in fact propose the same 5 years ago.
No, I never proposed it to this board.
Oh, there wasn't a discussion about
No,
that? Oh,
I asked if I could have my own.
Right, I mean, that's what.
And I was told flatly then,
Yes,
absolutely
right,
not.
and that was well before I ever proffered the
Yes.
question about joint client
Yes.
representation.
But I've since learned that other superintendents have this. They've recommended to me that I have my own, and I have not done it for 5 years. And Rita, financially, what were you going to say?
It would come out of fixed charges because we have to budget for attorney fees, and we have to budget for attorney fees for all kinds of unexpected incidences that may arise. So as far as the funding is in place.
That would be the
in
source of
fixed
the
charge.
funding. But is there enough money in that now?
Yes, yes, yes.
And what were we going to do with that money otherwise?
I always have to budget anticipating that there may be many variables, because one year I may have 2 cases dealing with students or employees, and another year I may have 20 cases. So therefore, as a prudent financial manager,
Sure.
I have to make sure that I have sufficient amount of funds budgeted to cover the unexpected, which is in most
I
instances.
get that part.
Okay.
So was this expected then?
What I just said was I have to budget.
Right.
And I have to plan for unexpected.
Right, I
I did
understood
not
that.
say this was
Right.
expected. I plan for unexpected, to cover you for attorney fees, to cover you for insurance, to cover
Okay.
you for all kinds of different.
Well, you answered the question. You said we
That's
have
right.
enough money in there
We do.
to cover this expense too. Okay, Mr. Destin?
Question, how much money is in there?
How much money is in there?
How much did you budget?
I have close to about $1.5 million, because I never know what may arise and what we may incur. And, you know, we have Title IX issues, we have student issues, we have employee issues. So if I just budgeted what happened the year before, then you could be put in a situation where you would not have adequate funds when something occurs that's unexpected.
Well, one, I guess, thing that we can say categorically is that it would cost more money to have two attorneys. Was that a safe statement?
I would
Okay, thanks.
assume so.
All right, so then what we'll do, then we'll proceed forward, and I'm sure we'll have lots of questions that we'll have for the attorney, and perhaps you'll have some for the superintendent as well. And I heard you say, Superintendent, that you weren't asking for a full-time.
No.
You were asking for a narrow area, I think,
Yes.
what you said was in terms of policy.
Yes.
Okay. Anything else, board members? All right, let's move forward then. Okay, we're going to item 13, board members' announcements. So let me start over there with Mr. Walker first. Mr. Walker.
Nothing.
All right, thank you. Mr. Destin.
Nothing tonight.
All right, Mr. Bryant.
Nothing tonight, sir.
All right, same for me. And moving through over to the bottom here, let's go over to staff. Anything? How about for the association? Mr. Butler? All right. Anything else, Mr. Attorney?
No, sir.
All right. This meeting is adjourned.